I kindly request all the participants to switch on their cameras and keep them on throughout the proceedings. In case of any technical issues, please ensure that the same is immediately communicated through the chat box. At the outset, we extend a warm welcome to our esteemed judge, Ritik Sekhar Srivastav, sir, for this round. It is my privilege as the court master to introduce the lordship present in this virtual courtroom today. Sir is a BA LLB graduate from Symbiosis Law School, Hyderabad, and currently an associate at Kocher and Co. with over 3 years of experience in civil and corporate litigation. Sir is specialized in managing complex legal disputes and delivering strategic solutions for the clients. With the permission of the Lordship, I shall now briefly outline the rules and structure of the today's proceedings.
Yes, please.
Each counsel will be allotted 15 minutes, subject to an extension at the discretion of the Lordship. We humbly request the Lordship to kindly keep the time framework in consideration due to a fixed schedule. During the arguments, I will be informing both the sides when 3 minutes remain, when 1 minute remain, and when time is up. In the event of connectivity issues causing an interruption, a maximum relaxation of 5 minutes may be granted, which is again at the discretion of the judge. The structure for the rounds will be as follows. Counsel 1 and Counsel 2 of the appellant will present their case and arguments first. This will be followed by Counsel 1 and Counsel 2 of the respondents. A stable internet connection is mandatory for all the participants and cameras must remain on at all times during the rounds. Judgments or documents may be screen shared only with prior permission of the bench. Rebuttals, if any, will be permitted solely at the discretion of the judges. Best of luck to the teams. With the permission of the Honorable Judge, may we now begin the session?
Yes, please.
May it please your lordships, the council seeks permission to approach the dais.
Please.
Much obliged, your lordships. Good morning, your lordships. The council recognizes the gracious presence of this honorable bench. For the convenience of the proceedings, may the council refer to the bench collectively as your lordships?
Only 1 year, so yes.
Okay.
Thank you.
Much obliged, your lordships. The council is appearing before this honorable court in the matter of ABC Bank versus XYZ Private Limited on behalf of the appellant challenging the order passed by the NCLAT. The lordships, the present matter raises 4 critical issues for determination. The first and the fourth issue will be dealt by me, and the other remaining issues will be dealt by my co-counsel. The council shall address these 2 issues for the next 14 minutes, reserving 1 minute for rebuttal. Your lordship, the council seeks permission to briefly state the facts of the case.
Yeah.
Much obliged, your lordships. Your lordship, the respondent corporate debtor was declared as an NPA in 2014 when it defaulted in making the payments of the loan which it had took from the appellant financial creditor. Subsequent to that, the corporate debtor issued various one-time settlement letters to the financial creditor from 2014 onwards. In 2020, an one-time settlement letter was sanctioned by the financial creditor in which the corporate debtor made another default in payment. Therefore, the financial creditor files an application for the initiation of the CIRP process, stating that the date of default to be 1st of May 2020. The application came to be dismissed, being barred by the Section 10A of the Insolvency and Bankruptcy Code, which was inserted to protect the companies which occurred genuine losses due to the COVID-19 pandemic. Then the matter goes before the NCLAT, and the NCLAT dismiss the matters too. Therefore, the financial creditor files another application stating that the date of default to be 1st of April 2014. The NCLT dismisses the matter on the grounds that the financial creditor cannot change the date of default on its whims and fancies, and the application is barred by res judicata. Again, the matter goes before the NCLAT and it dismisses the appeal on the same grounds. Therefore, ultimately, the matter is before this honorable court. If your lordship is well versed with the facts of the case, the counsel seeks permission to proceed directly to the arguments.
Yes, please.
Coming on to the first issue, whether or not a second application under Section 7 of the Insolvency and Bankruptcy Code is barred by law. Uh, Your Lordship, firstly, it is submitted that res judicata does not apply when where the prior application was not decided on merits. That the Insolvency and Bankruptcy Code does not explicitly prohibit the financial creditor from filing a second application. The doctrine of res judicata comes into play only when the earlier application has been finally adjudicated on merits. In our case, the first application was dismissed only because temporary suspension under Section 10A, and therefore it cannot be treated as a decision which had adjudicated upon the default or liability. The NCLAT, in the case of SBI versus Athena Energy Ventures, has categorically held that where a previous application is not decided on merits, a fresh, a fresh Section 7 application is maintainable as long as the debt subsists and the cause of action continues.
So,
This is
counsel,
that.
when you say res judicata,
Yes, your
what are
lordships.
the two main ingredients of res judicata?
Uh,
I'll tell you.
Lordship.
Same relief, same court. These are the two main
Yes, your
ingredients.
lordship.
Is it?
Yes, your lordship.
There should not be a same relief and there should not be a same court. It should not be before the same court again. So, in your case, what is the scenario?
Uh, your lordships, for res judicata to apply, like uh, if there, like if there is a different cause of action. So in the first application, there was a different date of default, and in the second application, there was a different date of default. So I believe that there are two different cause of action, and asking relief on two different cause of actions are two different things. So therefore, even if the first application is decided on the date of default, which is uh, 1st of May 2020, it does not bar the second application, because having a different date of default creates a different cause of action.
No, it's mere a technical change. No, how is the cause of action changing here? Because the relief you are seeking is the same. You're seeking for the admission of the corporate data
Yes, your
to
lordship, indeed.
CIRP, right? So the relief is
Yes.
same. So how come the cause of action is changing?
Uh,
Cause of action comes from where there should be a debt, there should be a default. That is all.
yes, your lordship.
Then,
Sir, your lordship, may I proceed with my submissions?
yeah, please.
Similarly, in the case of Dana Bank versus Shiva Kumar Reddy, the court held that part payments and subsequent acknowledgements may furnish a renewed date of default, and that a second application based on such renewed cause of action is not barred by res judicata. Therefore, thus the position is settled in law where the debt continues and the debtor acknowledges it. The creditor's right to apply under Section 7 is revived. Secondly, your lordships, acknowledgement under Section 18 of the Limitations Act creates a fresh period of limitation. Your lordships, this court in the case of asset reconstruction versus Vishal Jaiswal was conclusively settled the legal position that an acknowledgement of debt under Section 18 extends the limitation for IBC proceedings. Further, in the case of Lakshmi Patsurana versus Union Bank of India, this Honorable Court reaffirmed that a valid acknowledgement before the expiry of limitation triggers a fresh period of fresh limitation period, enabling a new Section 7 application. In our case, there are various written acknowledgements in the forms of the one-time settlement letters, which were dated from 2014 onwards. And the last one-time settlement letter which was issued was on 1st of January 2022, which is well within the limitation period. Therefore, these acknowledgements furnish a fresh cause of action for the second application. Thirdly, Your Lordship, the object of the Section 7 of the Insolvency and the Bankruptcy Code is to empower the financial creditor in case when there is a default which has occurred. The jurisdiction of the NCLT allows it to examine all issues relating to the insolvency process, including the date and continuity of the default. This Honorable Court in Swiss Ribbons versus Union of India clarified that the trigger for Section 7 petition is the determination of the default, not whether the corporate debtor is insolvent or unable to pay the debt or not. Therefore, once a default is established through documents and establishments, mere variation or change in the stated date of default cannot defeat the maintainability of an application under Section 7 of the IBC. If your lordships are satisfied with my first submission, the council seeks permission to move on to the next issue.
Yes, please.
Much obliged, your lordships. Coming on to the fourth issue, whether or not a case can be admitted if default has occurred and the application is within limitation despite an error in the date of default. Firstly, your lordships, I would like to point out to the object of the Insolvency and Bankruptcy Code. My lordships, it is humbly submitted that there is when there is occurrence of default is in dispute, the application is filed within limitation. A mere error or defect in stating the date of default cannot defeat the admission of a Section 7 application. The IBC prioritizes substance over form, and clerical inconsistencies cannot override the court's objective of resolving genuine financial issues. Secondly, your lordships, the Insolvency and Bankruptcy Code expressly permits correction of defects. The IBC itself provides for an opportunity to the creditor to rectify any defect or error in the application made for the initiation of the CIP
So if
process
you would have,
within a period of 7 days.
if the defects would have been rectified, it should have been done in the first petition itself.
Yes, Your Lordship, but I the an opportunity was not provided to the financial creditor to cure the error in the date of default, as the application was found to be barred by the Section 10A of the IBC.
No, you
So
are saying that you are
there was
saying,
no notice on part of the
yeah, sorry.
so, Your Lordship, there was no notice to the financial creditor given. The application was barred on dismissed. It was dismissed on this by pertaining to the Section 10A of the IBC.
No, when you were making the submissions before the NCLT in your first
Indeed, Your
application,
Lordship.
there they would have highlighted the same issue, right? So then you would have taken the leave of the court and you should have amended the pleadings. You should
Indeed,
have
Your
changed.
Lordship.
Yeah.
Indeed, Your
Then
Lordship.
then how come the second application and this appeal?
Your Lordship,
If the
as
rectification is allowed, it should have been done in the first appeal itself.
indeed, Your Lordship. Your Lordship, as I've earlier said, there was no such opportunity given to the financial creditor, and also the application being barred by Section 10A. Therefore, the NCLT did not hear it.
Okay.
Shall
Proceed,
I
proceed.
continue with my
Yeah,
Shall
proceed.
I continue with my submissions?
Yes.
Uh, uh, in the present case, there is no such opportunity was given to the financial to cure the error in default. Uh, Subsequently, the financial creditor makes another application with a delay of 2 years from getting the first application rejected from the NCLT. It is humbly submitted that this delay is condonable by the NCLT. This court, in the case of Surendra Trading versus Dugdilal Kamlapur Jute Mills has already held that the 7 period uh, limitation given in the section 7 subsection 5 is directory, not mandatory. Therefore, the NCLT is empowered to condone the delay in curing defects when there are justifiable reasons preventing rectification within 7 days. Even when the application is not filed within its prescribed period, the delay in filing of another application can be condoned, as it is observed that such period is not mandatory, and when there are weighty, valid, and justifiable reasons for not being able to remove the defects within the 7 days. Therefore, Your Lordship, it is humbly submitted that a case can be admitted if there is a default which has occurred and the application is well within the limits, despite there being an error in the date of default. My Lordship, the Council seeks permission to retire and allow my co-counsel to make submission on the remaining issues.
Yes, please.
Much obliged, Your Lordships.
May it please the court. I am the counsel appearing on the behalf of appellant. With your lordships for kind permission, I'll be proceeding to argument advance on issue number 2 and 3.
Yes, please.
Much obliged, your lordship. So the second issue of argument advance asks whether or not mentioning the date of default is mandatory in the application. Sorry, is mandatory in application under IBC. So, Your Lordship, my core contention is that omitting or erring on the exact date of default does not defeat Section 7's application, provided the existence of default is substantially proven. Your Lordship, IBC is piece of beneficial legislation. It places substance over form. Thus, the proof of default supersedes technical precision. The omission or technical error in specifying the exact date of default is not fatal for Section 7's application, provided the existence of default is proved. Section 7 clause 3 clause A of code merely requires the financial creditor to record the default and provide evidence thereof. It does not mandate the specific date. Once written becomes becomes and it becomes an unchangeable defect. So I place a strong reliance on the landmark case of Innovative Industries versus ICICI Bank, where the Honorable Court held that adjudicating authorities uh, primary duty is to ascertain if the debt is due or if the date has occurred. So, in the very present case, the debt of rupees 500 crores is undisputed. The the non-payment is undisputed. The respondent or the corporate debtor has acknowledged this debt repeatedly via OTS before from 2014 to 2022. Your Lordship, the NCLT dismissed our application on the ground of hyper-technicality. However, it is established fact in Dena Bank versus C. Shivakumar Reddy, the court should not be interpreted in a way that defeats the objective of the resolution. So also whether
I,
the date,
I have a doubt here. So wait.
yeah, this
So
is also
you're saying that date of default is not at all mandatory for NCLT to adjudicate upon a Section 7 petition, is it?
no, your lordship. I am saying date of default is mandatory, but it should not go beyond the objective of the mere clause. IBC's main objective is to get money from is to recover money, and on a mere
BC's objective is
technicality
not to
basis.
recover money, first of all, it is to revive the corporate debt.
It is to revive corporate debtor and
Right.
to recover money from it. So my core contention is that and it was held in the case of Dena Bank versus Shivakumar Reddy that it should be interpreted in a way that that objective does not get defeats.
Okay, ठीक है, चलो, I got your
Okay.
point. Now, answer me one thing.
Okay.
How will you calculate limitation for a Section 7 petition? If in case you are not considering the date of default, how will you consider the limitation?
Uh, when we sorry in our first in our when we sorry since the date of the since when we filed in section when we filed for the first time, it was barred under section 10A, and we were entitled to rely just on the default date of 2000. So now we are just relied on original date of default, that is of 2014, which is legally kept to acknowledge the debt because under section 18 of Limitation Act, the debt is kept only
No, you
regards
are
when
arguing that the date of default is not at all mandatory for deciding Section 7.
Your
Correct.
Lordship,
Then in that case, how will I consider limitation?
my mere contention is date of default is mandate is important, but
It's
it's not
important.
mandatory.
Correct.
Yeah,
Oh,
it is important, but it's not mandatory. It's not mandatory because
then
it
how
should
will
not.
I calculate my... Okay, so let's say there are five applications without date of default. How will I decide the limitation on it if it is
To
not
show the
mandatory?
default is 3 years from date of default,
Uh,
and in our case, it is continuing default because of OTS.
no. What I'm asking is, let's say I have five other applications with me to decide upon, and
Yeah,
there are no date of defaults mentioned because, as you said and as you argued, that it is not
yeah.
mandatory. Correct. So if it is not mandatory, they have not written it in their application. Now it is upon me to decide if they are within the limitation or not. How will I decide it?
So, Your Lordship, my contention is that it changes based on facts and circumstances. In our case, and in our case, it was completely barred by Section 10A. Merely because of
Correct. That
that,
is fine. I agree.
yeah,
I agree. But as far as the limitation is concerned,
yeah.
date of default is mandatory.
Uh, for limitation, but in our case, it was continuing default. It was continuing. So because of it was particularly, we cannot be stuck uh on to show that what was the date of default because in
Law
our case
doesn't
it was
change on a case to case basis, right?
but as per but we cannot be stuck with to show the default date.
Okay, you proceed with the arguments. Then.
Your
Consider.
Lordship, the NCLT, Your Lordship, the NCLT dismissed our application on the grounds of hyper-technicality. However, as established in Dana Bank versus Shivakumar Reddy, the court should not be interpreted in a way that defeats the objective of resolution. So whether the date of default is treated as date of NPA or OTS failure, or the facts remains merely on basis that money has been lost and uh, that a corporate creditor should not lose his money and he should revive. Thus, it's my contention that to dismiss the petition solely on the basis of mentioning date of default is to prioritize procedural formatting over substantive justice. May I proceed with issue number 3, Your Lordship?
Yes, please.
So the third issue of the argument advanced is on basis of whether date of default changes based on the facts or is it tied to the date of default. So your lordship, date of default is dynamic and is fact dependent. It is not rigidly tied to the date of
How
non-performing
is date
asset.
of default dynamic? As in, it keeps on changing.
It keeps on changing based on according to facts and circumstances. In the case of Lakshmipad Surana versus Union of India, it was held that it changes based on facts and circumstances. And in our case, because of OTS, it was continuing. Thus, it can
Correct.
be changed because,
Okay. Yeah.
yeah. So, Your Lordship, the lower court erred in equating the NPA date solely with the date of default. NPA is regulatory classification by the RBI, simply non-payment of dues. While the NPA date is starting point, the date of default evolves with when the corporate debtor acknowledges debt and promises to pay. Your Lordship, corporate debtor issued the separate letter requesting the OTS between 2014 to 2022. According to the case of Lakshmipad Surana versus Union of India, every time the corporate debtor acknowledges the debt in their balance sheet or via OTS, a fresh limitation begins and arguably a fresh cause of action is arose. So, Your Lordship, In the landmark case of Dena Bank versus Shivakumar Reddy, it was observed that subsequent acknowledgement can furnish fresh date of default. Also, we sanctioned an OTS on 1st February 2020, and the respondent failed to pay by 31st March 2020, and we cancelled it on 1st August 2020. So the moment we failed to pay the OTS amount, a new default occurred. Therefore, when we filed the second application citing the NPA date of 2014, supported by continuous acknowledgement, we were legally correct. We entitled to rely on an original NPA date read with subsequent acknowledgement that kept debt alive. Thus, to hold that the debt is frozen at the NPA date of 2014, ignore the commercial reality of banking where settlements are also attempted. The respondent cannot be benefited from their own multiple requests of OTA to delay the process and then claim that bank is technically barred because of date change. That
Who approves the OTS?
uh, it it was the corporate debtor who approached the OTS.
Who
They
approves? Who approves?
sorry,
Who accepts the OTS proposal?
OTS has been accepted by bank, but
Bank.
then
Correct.
yeah,
So how
but
are
we
you
were
blaming your thing on the CD? Because
but
you are also partially a part of it, right?
yes, but
Opposed to
no,
accepted.
yes, your lordship. It OTS are approved by us, but then we were under the consideration that by continuing OTS, they will pay, and then once the once they did not pay, we just we just file the case. But
Okay,
it
one final question. Why did you not rectify this particular defect in the first application that you had filed?
uh we did not can you repeat the question, my lord?
I'm asking why did you not rectify this defect? It was a mere date change.
It was more we did not your lordship section we did not do that because in 2020 in 2020 it was just barred by it was barred by section 10A, and the original cause of the because it was barred by section 10A, and because they defaulted and we did not because it was barred by section 10A.
No, I'm saying when your first application, which got dismissed, then again you filed the same petition by changing the date of default.
Yes,
Now it is hit by res judicata. So why did you not made the amendment in the first application itself?
because it was barred by section 10A, and then uh, it was for
Okay, only 3 minutes are left for you. So if you want to wrap up your arguments, you can.
so your lordship uh, so your lordship, I'll proceed with the prayer. If uh, if your lordships are satisfied with the argument advanced, the council humbly prays for the following relief. First, to set aside the impunged order passed by NCLAT, issues direction to the NCLAT to take up the matter and to pass any other order as the honorable court may deem fit. It was it was privileged to argue before the honorable court.
Thank you.
Thank you.
Now we can
Respondents,
proceed with the respondent.
you're on mute.
You are on mute.
Speak forward, yeah.
Pardon, Your Lordship. Your Lordship, I'm the counsel on behalf of respondent. I seek permission to address this bench as Your Lordship.
Yes, please.
Your Lordship, I am the I'm the counsel on behalf of respondent in the matter of ABC Bank versus XYZ Private Limited. If your lordship are well versed with the fact of the case, counsel seeks permission to proceed with the uh, questions of the
No, give me a brief of the
issues of
facts.
the case, sir.
Give me a brief of the facts. I want to hear
Okay,
your
your
side of the
lordship.
facts also.
Your lordship. Your lordship, counsel seeks permission to share the fact as mandated by the rules.
Yes.
So, sure. Your lordship, this is the matter between ABC Bank and XYZ Private Limited, where ABC Bank has sanctioned 500 crores of loan in favor of XYZ Private Limited and got regular payment throughout the year. From next year, payment got irregular and resulted into marking as a NPA. Your lordship, from the year 2014, several letters for the OTS settlement has been served to the creditor by the corporate debtor, and in the year 2022, 1st of Jan, last letter for the OTS settlement was issued, which was accepted in the month of February 2020, setting the last date for the final settlement was the 31st of March 2020. Your lordship, in the
2020,
same,
20.
uh, pardon,
2020, 2020, right?
Your lordship.
Correct. Okay.
Your lordship, the council would like to move to the para 5, which says in the year 2022, entire world was struck by the COVID-19. So, in order to save the corporates who are genuinely distressed due to outcome of the COVID-19, government introduced Section 10A throughout
Hmm.
the ordinance to save the companies from the insolvency proceeding. And your lordship, since the date of last settlement was 31st March of the 2022, last and this ordinance came into force from the 23rd of March. So
Hmm.
filing of the sorry, pardon,
Yes, please proceed. Proceed.
uh, your lordship, in order to protect the company, this ordinance worked as an sorry, your lordship. Due to pandemic, the government through on an amendment introduced Section 10A, which says no application whatsoever can be filed for initiation of corporate insolvency process. Your lordship, counsel would like to add, read out the section 10A, which
No,
mandate the
it's fine. It's fine. I know Section 10.
I
Your
was
lordship.
trying to, then there is some
The
problem.
financial
Now it's sorted out, looks like. Because I by mistake pressed that break leave reading. That's what happened. Now it's fine, it looks like.
Arpan, can you check, please?
Yes.
may I proceed?
Wait for a minute.
Yes, you can proceed now.
Yeah, can proceed.
Yeah. Your lordship, the financial creditor filed sec petition under section 7 of Indian Insolvency and Bankruptcy Code before the Honorable Company Law Tribunal against the corporate debtor, filed here on 1st of Feb 2022 by mentioning date of default as 1st of May 2020. Your lordship, the Honorable National Company Law Tribunal dismissed the case that it was barred by the availability of Section 10A of Insolvency Bankruptcy Code. An appeal was preferred before the National Company Law Appellate Tribunal, and the same was dismissed on the merit. Therefore, financial creditor has filed another application under Section 7 on 1st of January 2024 before the Honorable National Company Law Tribunal against the same corporate debtor by mentioning the date of default as the NPA, 1st of April 2014. Despite showing that the case was within the limitation, With the various OTS letter, the matter came to be dismissed by the Honorable National Company Law Tribunal on the ground that the financial creditor cannot change the date of default on its whims and fancies, as well as on the ground of res judicata. Your Lordship, another appeal was filed before the National Company Law Appellate Tribunal, and the same was also dismissed on the same ground. Therefore, a civil appeal has been filed by the financial creditor before the Honorable Supreme Court. Notice has been issued on the side appeal.
Present to side of the appeal. Yeah.
Your Lordship, Counsel would like to address the statement of jurisdiction, which is mandated by the Section 62 of the Insolvency and Bankruptcy Code. Your
You are
Lordship,
challenging
Section
you're challenging
60.
the jurisdiction of this bench. Are you challenging the
Pardon?
jurisdiction of this bench?
Your Lordship, the case has been already decided by the given fact on merit, and if case has no maintainability, this case is not fit for this bench. So that's what we are trying to convey.
No, what jurisdiction part you saying?
Your Lordship, this case has been tried by the competent court and National Company Law Tribunal and National Company Law Appellate Tribunal, and it was dismissed on citing the same ground with no merit.
Mhm.
So, Your Lordship, this case has no merit to be tried before this honorable bench.
Yeah, that I'll decide, but how is
Your
jurisdiction coming into picture?
Your Lordship, here jurisdiction is coming into question because this case was tried before the competent court,
So this is
which
under
is the
appeal.
national. Your Lordship.
Then, okay, proceed.
If your lordships are satisfied with the brief fact of the case, counsel would like to seek your permission to address the issues. Your
Yes.
lordship, counsel one would deal with the issue 1 and 2, and counsel 2 would deal with the issue number 3 and 4 with the prayer.
Okay.
Much obliged. Your lordship, this whether or not application under section 7 is barred by your law or not.
Okay.
Your Lordship, Counsel would like to submit that earlier petition was dismissed citing availability of Section 10A, which was enacted to prevent initiation of bankruptcy proceeding from 25th of March 2020 to the extended period. Your Lordship, as prescribed by the government through ordinance against corporate facing financial distress due to COVID outbreak and its impact, setting the bar date from the March 25th, 2020. Your Lordship, it falls under the given period. Your Lordship, availability of Section 10 as it reads, suspension of initiation of corporate insolvency proceeding. The insolvency proceeding, Section 10A, which says, notwithstanding anything contained in Section 7, Section 9, and Section 10, no application for initiation of corporate insolvency resolution process of a corporate debtor shall be filed for any default arising on or after 25th of March 2020 for a period of 6 months, such as period not exceeding 1 year from such date, as may be notified in this behalf. Your Lordship, provided that no application shall ever be filed for initiation for corporate insolvency process, resolution process of a corporate debtor for the said default occurring the sad period. For the it explains as it removal of the doubt, it is clarified that provision of this section shall not apply to any default committed under the sad section before 25th of March 2020. Your Lordship, Counsel would like to emphasize on the date which was set by the company was the 31st of March 2020, not before 25th of March 2020. Your Lordship, Counsel would like to read the Section 9 of the Insolvency and Bankruptcy Code, which says expiry of period of 10 days from the date of delivery of the notice or invoice demanding payment under Section 1 of the Section 8 if operational creditor does not receive payment from the corporate debtor or notice of the dispute under the Section 2 of the Section 8. The operation creditor may file an appeal before the adjudicating authority for initiating corporate insolvency resolution process. Your Lordship, Counsel would like to submit that Here, no notice for demand of payment has been served, nor it is mentioned or not in a whispered about this issue by the counsels appearing on behalf of the petitioner. Your Lordship, Section 7, which states financial creditor either by itself or jointly on person or behalf of patient creditor may notified by the central government may file application initiate corporate insolvency resolution process against corporate before the sorry before the adjudicating authority when a default has occurred. Your Lordship, here corporate debtor is the only party and nothing has been served to the debtor for before initiating any resolution process. Despite of serving,
You are
despite
saying that you are not given any notice nor any chance to contest the matter.
Your Lordship.
Where? Before which court?
Your Lordship, this court,
You contested in the first application filed, you won. Then you went into appeal, you won there. Then this is the second application, you won before the NCLT, you won before the NCLAT. Now it is before me, you are contesting here. How
Your
come you did
Lordship,
not get the opportunity? You won all the application, all four applications without contesting.
Your Lordship, we did not contested at any stage because we did not get a opportunity to represent ourselves. It has been dismissed while citing the prima facie no maintainability or lack of merit.
Okay, it
In
was
this,
just
in the
merit.
Your Lordship,
Okay.
Your Lordship, it is submitted that insolvency and bankruptcy code does not have provision of filing application for same cause of action before the same fora as it was barred by the principle of res judicata. Your Lordship, in the case of Satyadan Ghoshal versus Devrani Devi, All India Reporter in the year 1960, Supreme Court, page number 941. Your Lordship, Section 7, petition filed under Section 7, dismissal reached to the finality, and second is barred. Your Lordship, the final decision under IBC attains finality whether when multiple attempt cannot be entertained, which was laid down in the K. Shashidhar versus Indian Overseas Bank in the year 2019, Volume 12, Supreme Court Cases, page number 150.
No,
Your
what are you
Lordship,
trying to what are you trying to imply here?
uh, Your Lordship, here I am trying to convey that the second appeal cannot be entertained by the Honorable Court as it was precedent set by the earlier. It was the set precedent throughout the Satyadan Ghoshal and Devrani Devi, and while citing second judgment, where I'm trying to convey where the final decision it attains the finality and multiple attempt cannot be entertained.
Oh,
Much obliged, Your Lordship. Your Lordship, IBC proceeding should become indefinite or repetitive. Second application, repetitive attempt which violates the certainty of IBC process, sanctity of process must be preserved. This rule was laid down in the EBIC Singapore Private Limited versus Committee of Creditor of Educom in the year 2021, Volume 9, Supreme Court Cases, page number 401. Your Lordship, petitioner is abusing IBC by filing second appeal after dismissal, and Your Lordship, the court discourage relitigation and finality of adjudication is essential to prevent abuse of process. Your Lordship, Radhakrishna Industry versus State of Himachal Pradesh in the year 2021, Volume 6, SEC, page number 771. Your Lordship, it is further submitted that multiple Section 7 filing on the same debt are not maintainable unless fact material differs. Your Lordship, petitioner only changed the default date without even mentioning first cause and does not create any new cause of action. Your Lordship, the same principle was laid down in the Vistra ITCL India Limited versus Deccan Chronicle Holding Limited NCLAT in the year 2020. Your Lordship,
so
Counsel would like to.
answer me one thing. When you say there is no different cause of action, so when in the second application the date of default is changed, correct? So now for adjudication of Section 7, only three things are required. Debt, there is a debt, there is a default, and limitation. So for limitation, the sole aspect, they have changed the date of default. When the date of default is changed, the cause of action changed. Correct? Because that is when you defaulted. So how come you are saying that it is not mandated?
Your Lordship, council is misleading the court with the while citing again and again limitation under section 18. Your Lordship, this letter which was cited by the opposite counsel is the letter seeking OTS settlement, as it was
Right.
already sanctioned in the year 2022 in the month of February, setting the
Okay.
deadline for the 31st of March, Your Lordship. And your counsel on behalf of respondent, we are seeking the sorry, extension for the OTS settlement or approval for the OTS settlement sanction letter, as it was earlier approved by the creditor, which was fall under the sorry, yeah, which was under the COVID outcome, which did not fulfill. Your Lordship, Council would like to seek extra permission for the extra 2 minutes, since
Yes,
I'll
please. Yeah.
just
Yeah.
conclude with the
Continue,
yeah.
continue.
Your Lordship, second question which deals with whether or not mentioning dates of default is mandatory in application under insolvency and bankruptcy code. Your Lordship, it is submitted that date of default are essential elements and mandatory for initiating bankruptcy proceeding. In the absence of such application, rendered defective arise, and it is cardinal principle of law that date of default must be clear, specific, and consistent to test the limitation. Your Lordship, this principle was laid down in the Babulal Vardhaji Gurjar versus Veer Gurjar Aluminium Industries in the year 2020, volume 15, Supreme Court cases, page number 1. Your Lordship, petitioner's inconsistent default dates 2020, then 2014 makes the application defective. Your Lordship, in a quasi judicial body, consistency of the procedure shall not be altered. Your Lordship, quasi
How come
judicial body.
if there is any error in the application, how can it not be altered?
Your Lordship, Council would like to emphasize on the dismissal of the first petition. Your Lordship, first petition was dismissed while citing the lack of merit. Your
Okay.
Lordship, uh, Your Lordship,
Yes, yes, proceed.
Your Lordship, they had option of withdrawing the petition instead of getting dismissed. That petition was dismissed, not withdrawn.
Okay.
Your Lordship, quasi judicial body must ensure consistency in pleading and adherence to the procedure. Your Lordship, in the case of Transmission Corporation of Andhra Pradesh Limited versus Equipment Conductor in the year 2019, volume 12, Supreme Court cases, page number 697. Petitioner change in default date amount to inconsistency in pleading since rendered application invalid. It is submitted that incorrect mismatch default date lead to
I got
non-mental.
your point. Can you give me one judgment which says that date of default is mandatory for filing a Section 7 petition?
Your
One
Lord,
judgment. You have 1 minute left. If you can just give me one judgment which says date
Your
of
Lordship,
default is
Your
mandatory.
Lordship, in the case of Vijay Kumar Jain versus Standard Chartered Bank,
Yeah.
yeah, in the year 2019, volume 20, Supreme Court cases, page number 45. Your
Okay.
Lordship, it says wrong default date, failure to meet mandatory procedural requirement, and NCLT must ensure strict procedural compliance before admitting the corporate insolvency resolution process. Your Lordship, Counsel would like to emphasize on the point where the wrong default date has been mentioned or it has been altered
No, I'm
due to their
asking, do you have any judgment which says that date of default is mandatory for admission of Section 7?
uh, your Lordship, Counsel would like to cite that case in rebuttal round.
Right.
Your
Thank you.
Lordship, uh, Your Lordship, my co-counsel will address the issue number 3 and 4.
Right.
Your Lordship, Counsel,
You are not audible. Change your mic or speaker or something. No. Put on earphones if you have.
Am I audible, Your Lordship?
Yeah, better. No. Yeah.
Your Lordship, Council like to seek permission to proceed with issue number 3 and 4, Your Lordship.
Yeah.
Coming to issue number 3, Your Lordship, whether or not the date of default changes based on facts and circumstances, or it is to be taken on the date of NPA in all bank matters. Your Lordship, with respect this, it is submitted that the date of default must be consistent with declaring of NPA. Balance sheet entries are not necessarily acknowledgement default date. In Padma Kumar non-performing assets company, that is in the insolvency number 52 in the appellate tribunal of year 2020, it is mentioned, Your Lordship. It is further submitted that defaults during section 10A period cannot be used for corporate insolvency resolution process, Your Lordship. In Ramesh Kamal versus Simons Gamesh, that is in the year 2021, volume 3 SSC, page number 224, Your Lordship. That says that first petition used date of default as 1st 5th 2020 under 10A period. They cannot now use a different date to bypass the bar. Your Lordship, it is further submitted that petition changed default date to bypass limitations that is impermissible. Application under section 7 to be filed within limitation is strict. It cannot be manipulated or revived artificially.
But you approached the bank for OTS.
Yes, Your Lordship. But they have changed the date of defaults. I'm telling about that.
Yeah, so there can be multiple date of defaults, right? So let's say first you have
Yes,
taken
they
a
can be
loan of 1
multiple.
CR. For an example, you have taken a loan of 1 CR. Okay. For that, the repayment cycle starts from, let's say, 1st January 2026. Then again, on 31st December, you came to me saying that you want 1 crore more. So extend the loan facility. So the extended loan facility, the repayment date would start from 1st January 2027. Correct?
But in the appeal, they have changed the date of default for
Yeah, because
reaffirming
it
the.
changed because of the OTS.
But even petitioner, they cannot rely on OTS letters, by the way, when coming to the point.
How? Yeah, please enlighten me with that argument. Yeah.
In BK Education Service versus Prag Gupta, Your Lordship, that is in the year 2019, volume 1, SSC, page number 633. It is submitted, petitioner cannot rely on OTS or balance sheet to create a new default date, Your Lordship. So
Okay.
balance sheet do not get a new default date and sometimes not even acknowledgement, Your Lordship.
Okay, then how will I decide the date of default?
That is what the case is, Lordship, because they have changed the default date. This appeal is not standing.
So I'll tell you. Let's say you owe the bank 50 lakh rupees. Then you defaulted, and after a couple of months, you go to the bank saying that, okay, I'm here with the OTS. Kindly give me 6 more months of time, and I'll pay. You paid the first 3 installments, and for the other 3, you defaulted.
Even after giving the period, they have failed to repay the.
That's what. For the first 3 installment you paid, and for the other 3 you defaulted. So automatically the date of default shifted for the same facility that you had taken because of the OTS.
But they are on the stand of Section 10A, Your Lordship. So they are not on a stand of changing default dates by taking loans and all. They are stand on of Section 10A.
I did not understand what.
Stand of Section 10A by change default date, mentioning there was COVID-19 pandemic. So,
Yes.
in coming
So
to the matter,
after your last OTS, and, and if you take off section 10A, the date of default shifted accordingly, and that is how it is 2022. I think it's March or April 2022, which when they have filed it.
yes, from 2020 to 2014.
Yes.
I have further submissions. So in this, I will be clearing this doubt, Your Lordship.
Okay.
In V. Padma Kumar, that is five-member bench, reaffirmed in Assets Reconstruction Company versus Vishal Jaiswal. It is further submitted that petitioner cannot shift default from 2020 to 2014 to avail Section 10 or its limitations, Your Lordship. Default occur once. Limitation starts from original default acknowledgement that cannot change. Hence, they cannot change the change of default date, Your Lordship. It is also mentioned in the Jignesh Shah versus Union of India, that is in the year 2019, volume 10 of Supreme Court cases, page number 750, Your Lordship.
Okay.
The NPA date that mentioned 2014 or 2020 default cannot be alternately choose at convenience. It is submitted that default date is fixed and crystallized and it cannot be revised arbitrarily. It is
Okay.
and it is also mentioned in Ruchi Soya Industries Limited versus Union of India in the year 2019 SSC online, page number 404, Your Lordship.
Okay.
Your Lordship, if you are satisfied with the issue 3, may I proceed with the issue 4, Your Lordship?
Yes.
When coming to the issue 4, Your Lordship, that is whether or not a case can be admitted if the default has occurred and the application is within limitation, despite an error in date of default, Your Lordship. With respect, Your Lordship, it is submitted that case cannot be admitted if the default has occurred and the application is within limitations. Default must be proved to judicial satisfaction of NCLT. Inconsistency failure to satisfy NCLT cannot be satisfied when default date changed twice. There is no such material to suggest the change of date is responsible. Default date is responsible. Lordship, in Kuntal Constructions.
Sorry, what is the last line?
You want me to repeat the?
Yeah, the last line you said.
NCLT cannot be satisfied when default date changed twice. There is no such material to suggest the change of default date is reasonable, Your Lordship.
Reasonable. OTS, what about the OTS then?
Even the OTS also, Your Lordship.
You are taking a stance that OTS is not a credible thing to decide the date of default. That is your stance here, right?
Yes, Your Lordship.
Okay. Proceed.
This is also mentioned in Kuntal Constructions Private Limited versus Bengal Chemicals and Pharmaceutical Limiteds, that is in the year 2020, which was in NCLAT.
Okay.
Your Lordship, it is submitted that creditors must prove default clearly. If any doubts exist, petition must be rejected. As when coming to Mobilox Innovations Private Limited versus Kirusa Software Private Limited, that is in the year 2018, Volume 1, Supreme Court cases, page number 353, Your Lordship, it is submitted that wrong default date leads to failure of mandatory pleadings, renders applications are not maintainable. Your Lordship, mandatory procedure requirements must be fully complied with before admission, Your Lordship. In case Macquarie Bank Limited versus Shilpi Cable Technologies Limited, that is in the year 2018, Volume 2, Supreme Court cases, page number 674, Your Lordship, it is submitted that IBC cannot be invoked for uncertain or dispute defaults. Inconsistent dates lead to uncertainty, Your Lordship. It is also mentioned in Phoenix ARC Private Limited versus Ketulal Bhai Patel in the year 2021, Volume 2, Supreme Court cases, page number 799, Your Lordship, and held that petitioner
Can you give me
revised
one
default date
judgment
is
which says that date of default is mandatory for adjudication of Section 7?
Can you repeat the question?
I'm asking the same question. Can you give me one judgment which says the date of default is mandatory for adjudication of Section 7?
Just give me a second. of default is mandatory. Pardon your lordship, but we'll answer this if you're satisfied with this, we'll answer this question in the rebuttals, your lordship.
Okay. And conclude. Yeah.
Your lordship, with respect, I further submit that incorrect date of default rejection is compulsory. NCLT must examine the correctness of default as it is mentioned in Innovative Industries Limited versus ICICI Bank, that is in the year 2018, volume 1, Supreme Court cases, page number 407, your lordship. These were my submissions on the issue number 3 and issue number 4, your lordship. I'm grateful for your lordship's patience, and we the council on behalf of respondent pray this honorable court in the above light mentioned petition that is liable to be dismissed and pass in order that the court may deem fit for justice and good concise, your lordship. We humbly pray that this honorable court decide the matter in our thank you.
Rebuttals, if any.
If you please, Your Lordship, may I begin with rebuttals?
Yeah, 3 minutes.
Firstly, Your Lordship, my learned friend challenged the jurisdiction of the court. I would like to submit that the jurisdiction of the court cannot be challenged for these two reasons. That the case is discussing upon a very important position of law, which needs to be decided by the court. Secondly, if the case is not decided, it would hamper the rights of the financial creditor, which is against the objectives of the insolvency. And, uh, secondly, Your Lordships, my learned friend talked about changing the date of default time and again, makes the application defective. It is very much understood that the application can be defective, but such defect can be cured, Your Lordship, by under Section 7, subsection 5 of the Insolvency and Bankruptcy Code, Your Lordships. Fourthly, thirdly, my learned friend stated that the OTS and the balance sheet cannot be relied upon to create a new date of default, Your Lordships, in which they relied upon the judgment of BK Education Services, which is a 2019 judgment. Whereas in our memorial, Your Lordships, we have referred to the case of Asset Reconstruction India Limited, which is a 2021 judgment in which this honorable court has held that balance sheet of a company amounts to an acknowledgement of debt under Section 18 of the Limitation Act. Uh, that's my submissions, Your Lordships, on rebuttal.
Any sir rebuttals? Even 16 respondents.
Your Lordship, Council would like to raise issues which we have pursued and would like to raise questions with regard to questions posed by the my friend Council.
No,
Your
you
Lordship,
cannot raise
Council would
question, you
like
can
to.
only answer to it.
Okay. Your Lordship. Your Lordship, with regard to appellate jurisdiction, Your Lordship, Council we have already cited. This case has been decided by the competent court, and question has been answered with regard to merit. And Your Lordship, with regard to questions raised with regard to cured and uh, if this petition was defective and it wasn't cured. If it had been cured, it would have been amended and refiled, not dismissed and filed again. Your Lordship, and with regard to limitations set by the uh, organizing committee, with regard to page limitation was set by as prescribed. This team has crossed the page limit. So, Council would like to emphasize on the violating the rules of the organizing committee. Your Lordship, Council. Right. If your Lordships are done with the If your lordships are done with the sir rebuttal, I would like to answer the question posed during my argument session.
Yes, please.
Oh, your lordship counsel would like to seek your permission to share this. Your lordship counsel would like to draw your attention toward the JC Flower Asset Reconstruction Private Limited versus Deserve Exim Private Limited in the year 2023, IBC law, page number 378, NCL 80, National Company Law Appellate Tribunal, where it says date of default by the guarantor shall arise only when demand is issued by the bank. Your Lordship Counsel would like to emphasize on the point that creditor has not issued any notice for the demand of the payment for creation of date of default. Your Lordship Counsel.
Then how did you go for OTS?
TGA 16 speaker 1, your voice is not coming.
Chalo, we'll close it off.
I'm sorry. I'm sorry to
It's okay,
intervene,
it's okay. It's okay.
but I wanted to ask whether we can do Google search and show is it allowed?
Yeah, that
That's
is
what
what
I'm
I'm
asking.
not considering it. Yeah.
Yeah.
Right, we'll wrap it up.
Your Lordship.
Yeah, you're audible.
Your Lordship,
No,
counsel,
the other team is
counsel
objecting
was
to the
sharing.
Google search result during the competition, so I cannot consider this.
So, can I
Pardon, Your
conclude
Lordship.
the meeting?
Yeah, please conclude. Yes.
On behalf of the organizing committee, I extend our deepest gratitude to the Honorable Judge Ritik Sekhar sir for their time, patience, and the invaluable guidance shared with all participants today. Your presence has truly elevated the quality of this competition. Thank you, Your Lordship. And all the participants are hereby instructed to only leave this breakout room. Please don't leave the meeting at all. Thank you, sir.
All right. Thank you. Thank you for your time.
Thank you, Lordship.
Uh,